Ever since the pre-hearing at the Presidential Election Petition Tribunal, many have been wondering how Tinubu's legal team will defend all his baggages, most especially his forfeiture of $460,000 to the US government, being funds traced to narcotics trafficking. It's not just about whether he was convicted or imprisoned as a result, it's about the moral burden of having someone with direct links to narcotics as the president of Nigeria. Now that Tinubu's legal team have submitted their final address to the court, we will take them one by one to see the reasons they advanced in defense of his narcotics past. On Tinubu's forfeiture of $460,000 narcotics proceeds to the US government, the legal team said that the witnesses called by the petitioners were unable to point a single mention of the word fine in any of the documents they tendered as evidence. That one witness also admitted that the judgment was not registered in Nigeria in line with the Reciprocal Enforcement of Foreign Judgments Ordinance and Foreign Judgment Reciprocal Enforcement Act. That failure to register foreign judgments mean it won't apply in Nigeria. It can be enforced. They went ahead to cite some judicial precedents to support their argument, Grosvenor Casinos Limited versus Halui and others. They also said that the witnesses could not prove any conviction because they didn't tender any certificate containing any copy of a sentence or fingerprints and photographs of Tinubu. That failure to do that means that they didn't fulfill Section 249 of the Evidence Act. In further arguments to support this, they cited a judicial precedent, Oboru versus Ibori, 2006. Tinubu's counsel continued that the letter they tendered in evidence shows that Tinubu doesn't have a criminal record in the United States. They concluded by saying that they expected the petitioners to have, quote, apologetically dropped this arm of their petition while withdrawing the petition in its entirety. They are still begging for withdrawal of the petition at this stage of the hearing. Comment. Just like in the other video we made yesterday, they are still basing their arguments on technicalities. They are not arguing that Tinubu didn't have links to narcotics. Otherwise, how did narcotics money running into thousands of dollars end up in his account? They are simply saying that he wasn't convicted for it. Therefore, he can't be held responsible for any wrongdoing. The fact that someone wasn't convicted of a crime doesn't mean the person didn't do it. Many examples abound. Like people on the run. The police have evidence, but because they are on the run, they've not been brought to justice. So whatever their argument, the most important question here is, would you want such a person with links to narcotics to manage your company, not to talk of being president of the country? Can you, in all honesty, trust such a character? What is the consequence going forward in Nigeria? Does it mean that people with worse baggages will contest and become presidents in the future? There's a judicial precedent that the current Chief Justice of Nigeria was part of. In that case between Mohammed Abacha and the federal government, the honorable justices, while delivering judgment, said that forfeiture is the result of a crime. That if no crime was committed, a forfeiture can't be made. In Tinubu's circumstance, how did narcotics proceeds running into thousands of dollars end up in his bank account if he wasn't involved? Or if he didn't have the intention to launder the money? Remember that the money traced to his numerous accounts was way over what he could have earned legitimately as salaries when he was working as an accountant. So will the honorable justices turn around and agree with Tinubu's lawyers that the fact he didn't go to prison, he can't be held responsible for his actions that led to the forfeiture? Abacha didn't go to prison, but he forfeited billions of naira to the federal government. Coming to the Oboru versus Ibori case they cited, the fact that certificates and other documents of Ibori's previous conviction in the UK didn't pass through the bureaucratic process in Nigeria doesn't mean it didn't happen. He went to jail. They succeeded in shielding Ibori from justice despite his UK conviction in the 90s. He should never have been governor. So based on their argument, they are saying that despite the world knowing about Tinubu's narcotics past, the mere fact that the judgment wasn't registered in Nigeria exonerates him from the crime in Nigeria. Nigerians are watching to see how they will decide. On Tinubu's certificate forgery, his legal team didn't mention it in their final address to the court. Maybe they feel the documents tendered in evidence should speak for themselves. This includes the ones they tendered and the ones tendered by PDP. The question for the honorable justices to answer is whether the law allows someone to forge a certificate even if he owns it. Whether the certificate submitted by Tinubu to INEC is different from the one that Chicago State University issued during the time of his purported graduation. There are many judicial precedents that they can learn from, where the Supreme Court sacked politicians for certificate forgery. Will Tinubu's case be different? Nigerians are watching to see how they will decide. On Shetima's double nomination, they cited the Supreme Court judgment in favor of Shetima, but we all know that the new evidence introduced by Labour Party wasn't part of that trial that eventually went to the Supreme Court. In the video they tendered where Tinubu told newsmen that he has chosen Shetima as his running mate, the statement was made in Katsina, earlier than the day Shetima eventually wrote the letter to the APC. So we look forward to how the tribunal will decide.
Kashim Shetima. I have not discussed with him.
On the 25% requirement in Abuja, the summary of their argument is that going by Section 299 of the 1999 Constitution, that Abuja should be treated as a state. Therefore, going by the requirement in Section 134, that it should be taken as 37 states, that all votes cast anywhere in Nigeria should have the same value. Comment: we've made some videos about 25% requirement in Abuja. A lot of people have also given their opinion on the intention of the drafters of the 1999 Constitution. There's also judicial precedents to that effect. So let's just summarize by looking at Section 134 of 1999 Constitution. The subsection of interest is number 2, because that's where we are right now. More than 2 candidates contested the election. It says, a candidate for an election to the office of president shall be deemed to have been duly elected where there being more than 2 candidates for the election. A. He has the highest number of votes cast at the election. And, before we continue, notice the word "and" here. It means that the person must fulfill A and B. B says, he has not less than 1/4 of the votes cast at the election, each of at least 2/3 of all the states in the federation and the Federal Capital Territory, Abuja. This is simple English. By using the word each, it shows that it's talking about the states alone. After a presidential candidate scores 25% of the votes cast in minimum 24 states of the federation, he must still score 25% in Abuja. This is very simple. There's no ambiguity. All this long talk is not necessary. They are just throwing everything and hoping that one will stick. Don't they know the definition of the word each and? Even before the presidential election, many people accepted this as the norm, but they have somehow gone mute because Tinubu didn't score the required 25% in Abuja. Another hint that reinforces the mandatory requirement of 25% in Abuja can be seen in the same section 134, subsection 3. It says, the candidate who scored the highest number of votes at any election held in accordance with the said subsection 2 of this section, and one among the remaining candidates who has a majority of votes in the highest number of states. So, however, that where there are more than one candidate with majority of votes in the highest number of states, the candidate among them with the highest total of votes cast at the election shall be the second candidate for the election. This section is a follow-up in case there is no clear winner after the first runoff election. So you can see here there is no requirement for 25% in Abuja. So it's intentional by the drafters. And FCT is not a state like they are pushing it. There's no governor, no House of Assembly, no local government area. You only have municipal councils in Abuja. Only states, federal government and local government areas share federal allocation. We only have 36 states in Nigeria, not 37. Lands in a state are under the control of the governor. In Abuja, they are under the control of the president. Even when Lagos was the capital of Nigeria, the entire Lagos state wasn't under the Federal Capital Territory. This is in order to separate the powers of the governor and that of the president. So despite their citing Section 299 of the Constitution, Abuja is not a state. It is the Federal Capital Territory, just like Washington, D.C. in the United States. The president cannot function under a governor. There will be clash of powers. That's why they created a Federal Capital Territory where no governor is elected. The president controls the territory and acts as the governor. Because his duties are many, he is permitted by the Constitution to appoint a minister to oversee the affairs and govern FCT. It's for the same reason that the National Assembly approves the budget of the Federal Capital Territory. In every state in Nigeria, before one can become a governor, he must score the highest votes in the election. It's only fair to require 25% minimum in Abuja, so the law is meant to be obeyed whether you like it or not. Apart from other issues with the election and Tinubu's baggages, the one that is inescapable is 25% requirement in Abuja. Nigerians are not begging anyone to do the right thing. They are only demanding that justice be done. This is our constitution we are talking about. No amount of judicial and technical gymnastics will overturn 25% requirement in Abuja. It is there in plain language. All former presidents fulfilled this important requirement all the way back to MKO Abiola before all of them were declared winner. Tinubu's case will never be different. Thanks for watching.